Bazdaric versus Almah Partners. Counsel.
Good afternoon, Your Honors. Judge Wilson, I'd like to reserve 5 minutes for rebuttal, if I may.
Yes.
My name is Brian Isaac. As you know, I represent the plaintiff appellant. Before I begin, just let me introduce to you my co-counsel, Ms. Kaplan, who wrote the brief, and Devin Reif, who's the attorney of record. The issue I'd like to address with you first, if I can, is the issue of the integral to the work finding of the appellate division. As you know from reading our brief, we believe that the appellate division's decision went way beyond what the case law suggests, and we also submit that it goes way beyond what's actually fair. There's no question that there are some risks which construction workers have to take, and there are some risks which can't be guarded against. Your decision in the Salazar case is a perfect example. The plaintiff was charged with the responsibility of filling in a trench with concrete. He backed into it and he fell in. The plaintiff's claim was that there was a violation of the regulations requiring guarding. And as you pointed out, that was not a decision that made sense logically, practically, or in terms of construction practice, based upon the fact that the very purpose of the work was to fill in the trench.
So just a little bit on the word work. So is it integral to the work as in the specific task the worker is engaged in at the time of the accident, or is it more general as to what they may have been doing overall in the area?
Right. I think that the best way to look at it is first, what's integral with respect to the overall work, but it's really the task. And what I wanted to do, what I wanted to try to articulate to you today is the example that all of the lawyers, all of the judges, both on the plaintiff and defense bar, use when talking about integral to the work, and give you some examples to try to show you what my point is. The example we all use is someone cutting plywood at a construction site, because it happens all the time. The residue of plywood, right, when you cut it, is you're going to have sawdust on the floor. So very often it's said that encountering sawdust on the floor is integral to the work. And as a generic matter, that's correct. But as you know, we're in the Court of Appeals, and the devil is always in the details. If there is a practice and a procedure at a work site in which the owners, the general contractors, the people in charge have a procedure where they cordon off the area after the sawdust is cut, after the sawdust is there and after the plywood is cut, that's not necessarily integral to the work. The problem with the appellate division's decision from the plaintiff's point of view is that it talks about intentionality and purposeful use. That's not what I think integral to the work is. Integral to the work is intrinsic to the work. It's something that has to be done so that it's a risk that the plaintiff has to take.
So in this particular instance, there was a placement of plastic to prevent paint from getting underneath?
Correct.
And you would argue that that particular plastic wasn't integral to the work that the plaintiff was performing?
Correct. Judge,
And why would you say that?
not only would I say that, Judge Troutman, let me go even further. Not only am I saying it's not integral to the work, I'm saying it's antithetical to the work. And it's not Brian Isaac who's saying it, it's not Ms. Kaplan, it's not Ms. Reif, it's everyone. And when I say everyone, I mean everyone.
Does that also go to the fact that there was some suggestion by one of the supervisors, if he'd seen it there, he would have said, remove that?
That's correct. You're talking about Mr. Calamari's testimony. He's the superintendent for J.T. Mangan, and what he said was that this wasn't appropriate, it was wrong, and when he saw it, he ordered it removed immediately.
So let's just clarify something about this integral to the work with what we're talking about here. Is it your position that it could have been appropriate to request your client to paint the sides of the escalator and have nothing down? In other words, is a covering integral to that paint job anyway? Put aside what kind of covering?
Mm-hmm.
It's possible that that could have occurred. We know, as you know, Judge Rivera, from this record, that there were alternatives. In fact, Mr. Seton, who's
Yes, but that's a dispute over what would have been an appropriate covering. My question is a covering integral to this task in any event?
The record doesn't...
You could paint the sides?
Right.
Right?
The record doesn't make clear. It suggests that you should have some type of covering. There's no question about that. But this is the wrong covering.
Can you paint
Also,
without it?
if it had been something less slippery, like canvas instead of plastic. Would your argument be the same, that it's not integral to the work because it's the covering that's not integral, or is it the material out of which the covering is made?
So my answer to your question, Judge Canataro, is no. If they put on a proper substance and the procedure at the site was to have that substance covering it, it could very well be integral to the work.
But going back to what Judge Rivera was saying, painting, although it would protect the floor, was it necessary to cover it to actually do the painting?
It wasn't necessary to do the painting to have the cover. It was a protective device that they wanted
Right.
to do, but it certainly wasn't integral to that work. My point is, if you look at the work or you look at the work that the plaintiff's doing, fortunately, we claim it as the plaintiff in this
So
case.
for violations of the industrial code, which this is alleged to be, you do have to still show negligence, right?
Correct.
Okay, so I worry that we're conflating integral to the work and the reasonableness of what's been chosen. It is, I think some of my colleagues have been getting at. I do think there was testimony in the record that an appropriate covering for this would have been wood,
Correct.
right? So your position, we don't know, I suppose, whether it's okay to let paint drip onto an escalator, right? There's nothing on the record about that. Maybe that
correct.
destroys the escalator, maybe it doesn't. But for my hypothetical, let's assume you don't want paint falling to the escalator because it's a pretty hard thing to clean. It gums up the machinery and so on. And there is testimony that says wood on the planks is an acceptable substance. So I guess I'm wondering if the right way to look at this isn't some kind of covering when you're painting a mechanical thing like an escalator is integral to the work. And what we're really talking about is, was this appropriate, which goes to the negligence piece of it.
I think that's right. I think that's the way to look at it. The gravamen of this case isn't that some covering could never be integral to the work. It's that this covering was not integral to the work, and it was antithetical to the work. And there's one case I'd love you to focus on, if I just could. It's a Second Department case, but if you read the briefs on it, it's almost the same arguments my distinguished adversaries here is making. It's Lopez against New York City Department of Environmental Protection. Happens to be my case, the Second Department. It's a little old, but let me give you the facts in the case. It's a gruesome injury case. The plaintiff was working at a construction site. Unfortunately, he lost his balance, and there was an uncapped rebar, and it impaled him through his rectum. The defendant's position was precisely the claim made by my adversaries here. The rebar was integral to the work, and it was. You couldn't remove the rebar because it was going to be part of the superstructure. But the plaintiff's position was there was a rule, just like here, in testimony from the defendants, that rebar, sharp rebar, was supposed to be capped on placement. So the dichotomy was the rebar was integral, it had to be there, but the uncapped rebar was defective. That's our situation here. And in the Lopez case, plaintiff won below, it was affirmed on appeal, never got to the Court of Appeals, the case was settled afterward. But that's the distinction I want to make. I don't need to go past the fact that there are things that can be integral and things that might not be integral. This isn't integral as a matter of fact. Not only do I say so, but if you read Mr. Setton's affidavit, he's blaming the plaintiff for using the wrong instrumentality. And if you look at the defendant's brief, they say in the brief that it might not be the best choice. Well, if it's not the best choice, it could...
On this,
Oh, I'm sorry. I didn't...
Over here. Thank you. Didn't mean to interrupt. Can I ask you to change gears for a minute and address the foreign substance question? What is your reading of foreign substance? Does it include anything at all that is not part of the floor itself?
So, Your Honor, let me deal that in two parts, if I can. You're talking about 23.1.7 D1, obviously.
Yeah, I am.
Let's talk about the first sentence. And then I'm going to read something to you of your decision in Rizzuto. First sentence says...
Well, I'm happy to hear that, but maybe you could just tell me, do you think that foreign substance excludes anything, or is it anything that we find on the floor at all?
No, it's anything that's on the floor that's not supposed to be there. That's the definition I would ask you to have. You can have something on the floor. There are tons of appellate division cases where there are things on the floor. One of it's masonite, one of it's drop rags, because that was integral to the work. But if something isn't supposed to be there, it's a foreign substance.
So if taking the Chief Judge's exchange with you, if we assume, for purposes of argument, that it was appropriate to have some covering on the escalator, then I guess it depends a little bit on the level of specificity, right? I guess we'd have to conclude that this particular covering was not necessary, even if some other covering might be. I'm trying to,
That's correct. This covering wasn't necessary. The fact that this covering wasn't necessary doesn't mean that a decision from this court will have the precedential effect of saying that no covering can ever be addressed.
and so if the provision is read as broadly as you propose, why do you think the code has the more specific list first? Ice, snow, water, and grease.
Well, I think that you're talking about the justum generis argument. I think the reason that they
Yep.
have that first is, quite frankly, that those are probably the most common areas in which construction workers can get hurt. And I think the other term, and other foreign substance, would refer to anything else that wasn't supposed to be there. I would also point out to the court, as the trial, Judge Wilson, I'm sorry, my light's
Please,
on. Am
no,
I
please
okay?
go ahead.
Okay.
Go ahead.
I always ask permission before I go over. The first sentence of the regulation says, employers shall not suffer or permit any employee to use a floor, passageway, walkway, scaffold, platform, or other elevated working surface, which is in a slippery condition. It's a standalone provision, which...
Counsel, on that point here, don't you have a Ross problem if you're saying that's a standalone provision? How is that any different than ordinary common law negligence? Don't let your hallway be slippery. It seems to me the only thing you could violate is the second sentence, right?
Well, you're the judge, I'm just the lawyer, but let me read to you what you said in Rizzuto, because I think that that would be too narrow a reading, and then I'll promise I'll sit down. This is Rizzuto, 91 New York 2nd, at 7. Now, you're talking about the regulation specificity requirement. That regulation, in pertinent part, unequivocally directs employers not to, and then in quotes, and you highlighted this, suffer or permit any employee, close quote, close the italics, to use a slippery floor or walkway, and also imposes an affirmative duty on employers to provide safe footing by requiring that any foreign substance which may cause slippery footing, and then again in italics, you say, shall be removed to provide safe footing. The use of the conjunctive "and" makes me read that to say that it deals with both.
What was the last part of that sentence?
The use of the conjunctive "and" makes me believe that you were talking about both, and they're not integrated into one.
Okay,
I'm sorry,
but before you
both.
sit down,
I'm sorry?
I don't know if Judge Garcia had a follow-up. I'm
Both
sorry.
separately.
Yes.
That's
But
how you-
I think the easiest way to use foreign substance in connection with a 241-6 claim here is something that's not supposed to be there. That's foreign.
Well, Here,
sorry.
I'm sorry, did you,
No,
have-
no.
my apologies. Here is what I'm not clear about in the definition you gave. When you say thing, I don't think of substance as thing, because thing, I think, can be broader. So I want a little clarity on what you view the definition of substance is supposed to be.
I think it's a matter that is there that isn't intrinsic to the flooring itself. So if you have flooring, that's the flooring. Anything that's on the flooring could be a foreign substance, depending on the context and depending on the factual predicate in each case.
Even if it's a hard object, you would still say that is a substance.
It could be a substance, it wouldn't be a foreign substance. Anything that's not intrinsic would be a substance that would be external to
And why
what the
doesn't it
person
say
was
foreign
on.
object or substance?
Sorry?
Why doesn't it say foreign object or substance?
It just says foreign substance.
I understand that, that's
So
my
I
question.
think when they use the term foreign, they're trying to equate, and again, we're dealing with industrial code that's what, from 1967, hasn't been updated because of OSHA, which
Yeah,
you
yeah,
know.
yeah.
I think that what they mean is something that's not supposed to be there. To me, that's a sensible reading.
So something like floor wax, you're supposed to wax certain types of floors, that would not count as a foreign substance.
You're supposed to, you're certainly supposed to floor wax a floor, but you're not supposed to leave it in a condition where somebody can get hurt.
So that's on the
if
list.
somebody waxes the floor, they take the appropriate steps, and somebody says it's slippery under the common law rules from this court that go back 200 years, just saying like...
No, I'm not talking about negligence, so I'm talking about the reg.
Right.
Floor wax would fall under the foreign substance definition
Absolutely,
in the reg.
100% if it was slippery and you fell on it. No
Counsel, do
question.
you, under your reading of this provision, do you even need it to be a foreign substance if it makes the passageway slippery?
Well,
Because you're saying it's not a conjunct, you're saying it's, you could do either. You could violate the first part, which just says you can't make it slippery, let it be slippery, or you haven't removed ice, snow, water, grease, or a foreign substance.
Right. If we had our druthers, we would like you to hold that if there's a slippery substance in an area where
But
construction
it doesn't even
workers are
say
working,
substance, the first part. It
That's
just
right.
says slippery.
a slippery condition.
Right.
If you don't do that and you're not willing to go that far, then our position is that under the facts of this case, this is definitionally a, quote, foreign substance because everyone says that this device wasn't, the plastic wasn't supposed to be used.
But your position is that they're separate things, you can violate either.
That would be, that's how I read that section of the Rizzuto decision.
Yeah, well, again, before you sit down.
Oh, I'm sorry.
No, just to follow this up. So if I'm understanding you, the first sentence of 23-1.7D is that an employer cannot allow someone to work
Correct.
in the listed passageways, floors that are in a slippery condition. So the floor wax is actually a very good example. You put down the floor wax, they can't work on that. They wouldn't, right? They destroy the paint. But let's just go with it for one moment. You have to block it off, you have to tell people, whatever you have to do so no one goes on that. But once it is dry, that was the point. You wax the floor, now it's usable, so you're fine. The second sentence, though, is about removing
Yes.
something that may cause slippery footing,
Correct.
right? So I guess you want to remove snow. Perhaps there's not enough to make you slip, but you want to be careful about that. I think most people can understand grease and ice. These are obviously substances, I'll stay with that, that would make the flooring underneath, let's just put that, or the ground underneath, slippery. So both are affirmative commands, but the second one is a different kind of affirmative command, right? Because it
Correct.
requires
And the way-
the removal.
Correct. And the way I...
So let me ask you
I'm
this
sorry.
then. So is your position then that the plastic could have been under either? You put down the plastic and you tell them, well, don't walk on the plastic, don't use the plastic, although then they can't do their job, right? So it's a little bit nonsensical. But the second one is, it has to then be removed. And I have a little bit of difficulty on this second sentence with this. The removal seems very obvious to me. I'm still caught up on why a hard plastic covering is a substance, but let's put that to the side for one moment. Does seem ice, snow, I guess water and grease, a human being could put it on it, but it does seem that one would not put that on a flooring or a pathway because it would create something that slips. It sounds to me like it's accidental or it snows and it gets on the property, and that's why you have to remove it, because it's not something you would otherwise have had there.
That's,
Am I kind of getting that right?
Yes, I understand what you're saying, that's correct. And the way I phrased what you were phrasing, Judge Rivera, was, and we also went into this in the reply, the general textual content, the way that
Yeah.
the regulation is phrased, not just with respect to these regulations, but with other ones, is the first portion, those first sentences in each of those is prohibitory. Don't do X. The second one is directory. This is what you do in situation B. I'm sorry for going over.
Oh, thank you very much.
Good afternoon, and may it please the Court. And with the Court's permission, I'd like to address the arguments in the following order. Either 1E or D, 1D, and then what the integral to the work argument, which has garnered the lion's share of the argument.
I just ask you, since we were just talking about
Let's talk
D,
about D
why don't-
first.
Yes, just to kind of keep the flow of it.
Sure.
Excuse that phrase. Do you agree with this reading? I assume you don't, but could you help me understand what is your reading? I've read your briefs,
Sure.
of course.
First and foremost, the primary difficulty with the appellant's argument is that it reads Section 2 out of it. It renders it superfluous.
Okay.
And of course, one of the primary canons of statutory construction is this Court should strive to avoid that result. So first and foremost, that is a problem with the appellant's read of the argument. Second, I'd like to draw to the Court's attention, they don't cite a single case.
I'm a little confused, though, on why you think they're reading the second sentence out of it, if you read it the way he suggested.
Because, as we just heard from Mr. Isaacs, anything's a foreign substance,
Okay?
right? But under the canon of construction of the justus generis, We have specific examples followed by the general. So they all those specific objects have what I refer to as a viscous quality. And I thought the wax floor question was an interesting one because that, by definition, wax, people slip on wax. And if you look at the second sentence, wax is something that can be sanded, right, to be removed. So again, we're talking about this viscous quality. There's nothing inherently...
Counsel, they're also slippery as well. Well, first of all, I would maybe spend a little time arguing with you whether water is viscous, but the
But it's
common...
slippery.
Yeah, but they're all slippery, right?
Yeah, absolutely.
And so is plastic, or plastic sheeting. Maybe I should be recusing myself, but I've stood on plastic sheeting. It can be slippery. So what limitation are you suggesting here?
So first, there's nothing inherently slippery about plastic, and the description was, and I got called to
There's nothing
task,
inherent-
it was hard plastic. Whether it's a hard plastic shield, hard plastic covering, it was hard plastic.
Oh, it wasn't sheeting? It wasn't that filmy plastic?
There's the record, I don't think the record actually amplifies what it was, but Justice Edmeade specifically referred to it as hard plastic. Okay? And
Does that somehow make it safer?
no, but it certainly doesn't necessarily, it's not inherently slippery. That's the sole point
What
I'm
about
making,
those
Your Honor.
saucer-shaped sleds that kids go down in snow on? Those are pretty slippery, and they're made out of hard plastic. I mean, I can think of lots of things, air hockey pucks, there's all kinds of things that are hard plastic that are kind of slippery.
Sure, hard plastic can be. Remember what I said, Judge. It's just that it's not inherently slippery. That's all I said.
You mean you could make some type of hard plastic that was not slippery?
I think so.
Okay.
That's not my area of expertise, so I don't want to represent one way or the other. But I do want to get back, it reminds me...
I'm sorry, could you just finish the question? What is the rational limitation, since I think even you would agree, that ice, snow, water, grease is not an exclusive list of foreign substances which may cause a slippery condition. So what is the rational limitation with respect to the rest of that list, whatever it may be?
That which is inherently slippery, such as water, grease, oil, that which has a viscous-like quality, but hard objects. I think a natural read, somebody looking at this provision would say, and employing the doctrine of jus generis, which I understand is not dispositive, but it is a very well-honored canon, would say, really, hard plastic? That's just not it. So we're looking, as we said in our brief, to viscous quality, something that is inherently slippery. I think it's a better way of looking at it. Again, look what they talk about. Grease, ice, snow, water, grease. They could add oil, wax, things that one would expect to slip on necessarily.
Banana peels?
Since we're,
I'm sorry, I didn't hear.
Banana peels?
Well, I was thinking about that. I don't know the answer to that. I know people, certainly we see in the cartoons and in the movies with the Keystone Cops, people slipping on banana peels.
Well, that's what pushes the envelope.
Counsel, since we're-
Whether substance means something other than an item.
Oh, I think it has to mean some form of item, just from an ordinary,
Must be an item. Okay.
I believe so. Yes,
Judge
Judge.
Halligan.
but couldn't it be this? It seems like we're struggling a bit. I think with this canon, what you're looking to do is to identify a characteristic that each of the more specific words shares, and then you argue that the more general word is cabined by whatever that characteristic is. And it seems like we're struggling a little bit. Maybe hard plastic is inherently slippery, maybe it's not, they're not all viscous. Couldn't it be that these are all substances that one happens to perhaps see in a construction site, just given the nature of it, and it's not actually an effort to cabin the meaning of foreign substance?
I don't think that's correct, Judge.
Okay, so why not?
Again, when one is looking at the plain language of the statute, you're looking at what constitutes a slippery condition. These items all modify slippery condition. Otherwise, we get back to the point I made, we get back to the point I made earlier.
But then if the
Just
plastic,
that this second sentence gets read out of the analysis.
assuming that they each have separate application. But
Well, I
if
think,
it's,
I'm sorry, Judge.
no, go ahead.
No, I think, again, this is what they mean by foreign substances. It's the foreign substance that has to cause the slippery condition. Right? And one thing I'm reminded of, my brother once said to me, you know, Scott, if mom and dad agree, it's got to be right. And what he meant by, and what that means here is each of the courts that have interpreted slippery condition or foreign substance, and again, they don't point, the appellants don't point, have all looked at these types of materials.
Well,
The-
wouldn't they have changed the language then? And first, I would love to have a kid like your brother Scott.
I'm Scott Jett, right? Well, okay.
But in any event, wouldn't they have said something like in any other such substance? We use that, and there are other statutes that say they are similar to.
No, I don't think that's right, Your Honor, because why would they have to do that? Again, I fall back onto the doctrine of the canon of construction of jus generis. That's what this means. The general, when the general is followed by the specific, it's referring to the specific items or akin to it, similarities. What was the, we cite in our brief, but paraphrasing the doctrine, it's people, neighbors, keep the same company. And so why that adding language runs afoul, if they wanted to do that, why would they? And again, they don't point to any cases that support their arguments. If I want
Can I just ask you quickly before you leave on this? There's this word foreign, which we haven't talked a lot about.
1 second, just, can I have some water, please? Sorry. Yes, Judge.
And Judge Halligan posited that maybe what the list includes are things that one typically encounters on a work site. And foreign would seem to suggest possibly the very opposite of that. It might suggest that the kinds of substances that this second sentence is talking about are things like ice, snow, water, and grease that one normally wouldn't expect to see on a work site.
But I think that supports our argument.
Well,
Because their definition of foreign means literally anything. They literally, and foreign, in a dictionary sense, in a definitional sense, foreign means anything which one does not naturally find. It's that which should not be where it is. That's what they say in their brief, in their opening brief. And when we point out that could mean the drop cloth, that could mean paint cans, that could mean the paint roller, it could be anything.
but not a piece of plastic?
No, plastic shields, you need, and I'm going to get to this in the integral work
It sounds
argument.
like integral to the work now, yeah.
Right. It's something, but can I just very quickly go to the passageway argument?
Yeah.
Right? Again, they don't cite any case law to support this proposition. This is clearly a work area and not a passageway. They don't put up any other than a footnote in their footnote, which is page 20, footnote 9, where, again, they raise this argument for the first time in their reply brief. So the court can also find a waiver. Again, I get it was raised below, but we didn't have a chance to respond. This argument of passageway versus work area is raised for the first time. It's in a footnote. They cite no case law. And there's a case that Mr. Isaacs is well aware
Well,
of,
why isn't it an elevated working surface? It's an escalator.
but it's out of operation.
Yes, but
And
it's on an angle, sir, it's not, right? I mean,
But this is where he's working. I direct the court's attention to Diskevich versus the City of New York, which is 218 AD 3rd 546, in which the Second Department found that this was a passageway and not a work area. And here's the description. At the time of the incident, the plaintiff was moving various items from a third-floor classroom to the basement. After having made 5 to 10 trips traversing the same stairway, while carrying half of a metal door frame down the stairway, the plaintiff allegedly slipped on clear, sticky liquid, which of course would be a foreign substance with the meaning of 1D, on the top step going from the second floor to the first floor and fell down approximately 13 steps. That is a passageway. When you are stationed here, where at the top of the stairs painting and not moving, and the escalator is not moving, a passageway denotes going from point A to point B. There's no point A to point B. So now let me get to the integral to the work. There's a few, unless there's questions, I'm
And
sorry.
it cannot be used from point A to point B?
I'm sorry?
It cannot be used in that way?
Not when
Even
it's,
when it's not in service?
no, because,
Walking up and down an escalator?
But he's not, he's there. Again, this is not open to the public, this is not, this is not multiple people
But he's
using it.
painting the sides, right?
I'm sorry?
He is painting the sides, or that was his task,
I believe that's right,
right?
Judge.
One would have to move up and down that escalator to do that, would one not?
Sure, but it's his work, he slips in his work area while he's working.
Okay.
So, the integral to the work doctrine. I want to ask the court to make, regardless of where the court comes out, I think the bar and, more important, employer, or general contractors and employees would do well if the court made a few points. First, the court should hold that it applies to all provisions of the labor law. And what I mean by that, in O'Sullivan, this court held that it applies to 23-1.7 E1 and E2. In Salazar, the court held it applied to 240, 246-1, 23-17.1B. I think because in the dissent, if I recall correctly, of the appellate division, they made the point that it doesn't apply to one of the either E1 or E2, and I just think that's just incorrect. And when you think about the purpose underlying the integral to the work defense. And I'm not sure appellants disagree with that. They don't raise that in their briefs. To answer, I believe it was your question, Justice Rivera, is it necessary, you asked the question, is it necessary, unique to the work being done, or is it just something larger? In the specific case, it doesn't matter because it's the work being done, but one of the things that struck me is that, and I think the court should hold that it applies to both the work being done and the larger picture. But here, there's a good definition from, by the First Department in Sinai versus Luna Park Housing Corp., interpreting this court's decision in Salazar, that said, the test is whether eliminating the alleged defective condition would be, quote, impractical and contrary to the very work at hand, end quote, and inconsistent with accomplishing a task that was, quote, an integral part of the job. Here, one could only imagine what the argument would be if there was no plastic shield. Again, there's a separate argument that the device used the hard plastic, whether you want to call it a shield covering, but hard plastic, as Justice Idmead said, was improper. Right? If there was nothing and the paint was dripping, we'd be in 23-1.7D because paint, as an example, Justice Howley, paint would fall under this definition of a foreign substance causing a slippery condition. And we could only hear them, you had to have done something. So as the majority decision in the appellate division held, using something as a staging, in a staging area where the work needs to be done to protect is integral to the work. Again, I get they're raising an additional argument that what was used was improper. But, and I think as the majority decision mentioned, they cite two First Department cases, Johnson, right, and, if I pronounce this correct, Raj Kumar. In Johnson, there was plywood that was purposely laid to protect the sidewalk. That strikes me as integral to the work. Something needs to be laid. And again, we'll get to the point of, can it be any, I see my time is up. May I continue?
Please finish, yeah.
Okay. And then in Raj Kumar, it was construction paper that was purposely laid over newly installed floors to protect them, right? That is integral to the work, right? To the task, right? And so I think properly understood, the appellant's argument needs to be, is, or should be, that the protective plastic shield was the wrong object, and certainly Mr. Isaacs made that argument. But the court needs to balance, right, who are the experts. And what I mean by that is that the court shouldn't assume the role of OSHA inspectors. Right? There needs to be some leeway provided to general contractors. And here in the record, I think one other point that gets lost, and I think if the court disagrees on the issue of integral to the work, there's an issue of fact that needs to be decided by the jury, because in the accident report, Mr. Calamari indicated, and Justice Edmeade notes this in her decision, that it was placed, the plastic shield was placed by Cara, which is the employer. Right? And then there's the the affirmation or affidavit from the foreperson, Mr. Sestine, I believe is his name, who Mr. Bazdaric refers to as Jimmy, right? And he submitted an affidavit in which he suggested that it was plaintiff himself who chose that. Obviously, the plaintiff denies that, but I think if the court disagrees with the First Department's decision on the integral to the work argument, there should be a remand for trial because there are disputed issues of fact. But while obviously the court should address the integral to the work argument, because that's one of the reasons why we're here, but the court, regardless of it, if it affirms or agrees with the First Department, an affirmance is necessary, but the court can also rule in favor of the appellant on the integral to work, but affirm if it agrees with us, meaning the respondents, on the D1 and the E1 arguments, then an affirmance is necessary. And thank you very much, everybody.
Thank you.
Your Honors, my adversary is correct. I did lose the Discourse case in the Second Department, but they did find it was a passageway. My adversary keeps talking about leeway and that you shouldn't be determining what's good or what's bad. That's not my claim. I never made that claim. This is what Mr. Calamari said. It's not me. This is Mr. Calamari, the T.J. Magan foreman. This is on 243 carrying to 244. On page 25 at 243. Question. When you went and observed the escalator after this accident occurred, did you observe the plastic, and it's not hard plastic, it's just plastic, that was covering the steps of the escalator? Answer, I believe so. Question. In your opinion, was that the wrong type of covering for the escalator steps? Answer, yes. Question. Had you seen that before Srecco, that's the nickname for the plaintiff, had his accident, would you direct Sem, that's Mr. Senton, his supervisor, or Mustafa, who's the owner of Cara, to take the plastic off and put more safer covering on those steps? Answer, yes. This isn't a matter of discretion. This is a matter of undisputed fact. And I think the problem with my adversary's argument is one that, Judge Wilson, you and I alluded to just before I stopped talking, when I spoke too much anyway. It's the nature of the industrial code. This is a code that isn't being updated. I don't think it's been updated since 1967. And the reason is because we have OSHA, which is exceptionally detailed. Now, I know every single court that has considered the issue has said OSHA does not give you a predicate basis for establishing a 241-6 claim. But why? Why would a court construe labor law sections that deal with strict liability or vicarious liability under 240 and 241 narrowly when this court has held for over 150 years that construction workers like the plaintiff are, quote, scarcely in a position to protect themselves from accident, though danger looms large? That's Quigley against Thatcher 150 years ago. Using the wrong material on a site should not be exculpated under an integral to the work defense.
Let me ask you about counsel's definition of integral to the work, which I'm not going to be able to restate very accurately, but it was something to the effect of, if there is something that is needed for the work you are doing, and avoiding that would be a sort of an unreasonable cost, that thing is integral to the work. Does that sound right?
That may well be right. This is not that situation. So
No, I'm just asking about the definition.
Sure, and I get it. That's the Salazar case. I think Salazar was completely correctly decided. You can't apply an industrial code section dealing with barricading when the very purpose of your work is to cover up the hole. But here, every single person says this is the wrong device. It's integral to the work when it's antithetical to it at the same time, and we're going to construe labor law provisions with respect to an industrial...
Well, it really sounds like what I think you're arguing is that a covering could be integral to the work, but not this covering.
That's
which is now we're full circle on this particular argument on this appeal.
Judge Rivera, that's 100...
And he says courts don't get to decide that. Experts will decide what would have been the best covering. What's your response to that?
Not here. Here, everybody, every single fact witness who testified, including his client, Mr. Seton, who blames the plaintiff for using the wrong thing, says this is wrong. I shouldn't lose this case summarily. Thanks for listening to me.